Hey everyone, I want to talk to you this morning about neuropsychological testing as it is applied in a litigation setting. Now, I've talked about this area a few times before, and the reason why I kind of focus on this is because, traumatic brain injuries usually occur because of an accident, and many accidents result in litigation because a person is severely hurt. So what I want to focus on today is the notion that neuropsychological testing is based upon a series of tests that are given, and then they're scored. And the scores, depending on the score, then that area of cognition or learning or understanding will then be characterized by the test maker according to the test manuals. So for example, if a person in a particular area of testing scores from, say, 36 to 50, that may be mandated by the test maker to be characterized as, slight impairment. The problem with that is that the tests, when they were made by the different test makers, those numbers and those conclusions in terms of labeling that area of testing as slightly impaired are based on the general population. Now that's a problem because depending on a particular person, they may have done really well in school or they may have a college or a graduate degree, and so that the idea that it would be slight impairment for the average person would then translate to perhaps moderate to severe impairment for someone who had previously, prior to their injury, performed intellectually at such a high level as to attain those degrees. So all tests are not created equal, and it's important in this litigation setting to be aware of that. So if you or your loved one is being represented by an attorney and they are not aware of that, it's a good idea to bring that to their attention, because eventually when either your expert neuropsychologist or the defense's or the insurance company's neuropsychologist is deposed, that's a very fertile area of questioning, because any neuropsychologist that is going to be intellectually honest will readily admit that a person with an advanced educational degree should be characterized differently according to the test scores when compared to the average population for which those scores were originally promulgated. So that's a big area of concern. Now, to arm yourself with that, it's important to go and secure previous educational documents. For example, if there are high school transcripts or college transcripts or graduate school transcripts, it might be a good idea to arm yourself with those for the deposition so that your attorney can then show that to the neuropsychologist and get them to understand that this slight impairment for this particular injured party may actually be moderate to severe impairment when compared to their pre-morbid or pre-injury status of high functioning. I sure hope this video helps you, and we'll talk again soon. Thanks.